Hey everybody, I am going to bore you with the phrase testamentary capacity, but it's actually one of the most important things you can have to make sure your estate plan actually works. Before I dive into that though, let me tell you how to reach out to me. You can find me at my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, let me dive right in. Testamentary capacity might sound very boring, but it's actually it's one of two ingredients you must have to have an effective estate plan. The first part of an effective estate plan is to actually have the correctly done documents. So the documents have to say what they're supposed to say, they have to follow the laws that are required for these documents, and they must be signed, notarized most of the time. And as long as you do all that, that's the first part. And that's what part most people worry about. That's the part that you're trying to figure out with your attorney and you talk to them and all that good stuff. But the second part is really kind of out of your control, the testamentary capacity. Now, if you do not have testamentary capacity, you cannot have an effective estate plan, even if it's signed, notarized, done correctly, the whole 9 yards. And the reason why is because testamentary capacity is defined by the ability to understand what you are signing and what the contents of what you are signing is, and to understand your bounty, as they call it. What that really means is just you understand what's going on. As you sign the documents, you have intent to sign the exact document. You want to make sure that your assets are split up a certain way. And there's actually a lot of fascinating case law on this very topic where if you don't have testamentary capacity, your estate plan doesn't count. And that happens actually sometimes when people say, I want to give away my unicorn to the president of Somalia, something crazy. And there have actually been cases where people address what happens if you're trying to give your unicorn to the president of Somalia. Now, that's a made-up example. I forgot exactly what it was, but there are cases out there of just very peculiar assets going very peculiar ways. So that's all to say that this applies specifically for those who lack or are struggling with testamentary capacity. More specifically, I'm kind of thinking of people with Alzheimer's or dementia or have severe depression and they are in the throes of a depressive spell. Whatever it is, there are instances where people do not have testamentary capacity to sign these documents. And if you have a loved one that you are trying to have sign these documents, there may be instances where you should not have them sign and actually wait until they recover or have a better day or something like that, because the moment you sign, you must have testamentary capacity. You could lose testamentary capacity entirely beforehand, have an hour of sobriety where you understand everything perfectly, and then everything else for the rest of your life has no testamentary capacity. If it's just for that hour, if you happen to squeeze in there and get those documents signed, it counts and it works. But if you don't, and you don't actually get it in within that hour time frame, those documents are invalid by default. And if somebody contests those documents, they're done. They don't count. And oftentimes when they don't count, you go to the default laws, and the default laws will split things up differently than what you put in your will, possibly. So that's why it's a big concern to have testamentary capacity. Now, if you see somebody who may or may not have testamentary capacity, it's hard to tell. I would strongly recommend sitting them down, explaining the documents, explaining exactly what's going to happen, ask them questions that they must know the answers to in order to validly sign the actual documents. If they don't and they can't answer correctly, then perhaps you should wait, or perhaps you should figure out some other path. But if you can figure that out and they do have testamentary capacity, go ahead and sign right then and there. And if you're really worried about it because you're worried that your siblings are going to bust up the trust later on or something, then record it. Record your interview with that person so they can prove later on that they absolutely had testamentary capacity when they signed the documents. Otherwise, again, somebody could come in, bust up the documents, the default laws apply, and the default laws could favor the person busting up the documents instead of you. So it's an unfortunate reality, but a lot of people start suffering with dementia and Alzheimer's and other mental diseases later on in life. And these are ways that you can prevent those diseases from invalidating the documents later on, even though they were done perfectly. So with that, if you guys have any other questions on that front, if you have any other questions on estate planning and probate in general, I'd be more than happy to answer any of them. You can email me directly and I'll respond directly. Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website and you can go onto our Contact Us page and schedule a consultation directly onto my calendar for free at www.legionlawpllc.com. So with that, thank you so much for watching and have a great day.